are slightly different. But a series LLC is a special type of limited liability company that can be segregated into separate series. Now, I don't like the term series because the word series sounds like a multiple, a plural entity. And each series, if you can imagine, is in reality a separate subsidiary of sorts. But the separate series or boxes, if you will, can hold assets separately in each of those boxes, and rather than combined in a single entity. And under the series organization laws, the series organization is referred to as a cell company, and the series referred to as cells. I like that term a lot better because a cell can be a single word, and cells denotes plural of many cells, and the cell company implies that there is in fact a parent. But for the time being, we're stuck with the term series, and that's tracking the language that was used in Delaware. Each separate series or cell can have its own members, managers, or membership interest. They can be separate and apart from the other series within the same parent series LLC, or as I say, cell company. And each cell or individual series may have rights, powers, and duties with regard to specific property or obligations that are separate from the rights, powers, and duties of the other cells or separate series. And then finally, each separate series may have its own allocation and distributions of profits and losses associated with the property that it holds. So you can see the power and flexibility of this as an entity that will hold title to real estate. A cell or separate series may have a business purpose or investment objective that differs from the business purpose or objectives of the other cells or separate series. And each separate series or cell can sue and be sued, can contract, can hold title to property, and can grant liens and security interests in its assets, all on its own behalf. So, as I say, I don't like the term series because it's a plural term to begin with, and you're going to hear me using the term separate series, or better yet, referring to it as a cell. A separate series or cell by the statute is insulated from the debts and liabilities of the other cells and those of the parent cell company. In the Texas language, a series is by statute insulated from the debts and liabilities of the other separate series and those of the parent series LLC itself. And the debts, liabilities, and the other obligations of a particular cell or separate series are enforceable only against the assets of that particular cell or separate series. And then the debts and liabilities and obligations of the parent series LLC itself may not be enforced against the assets of a separate series or separate cell. So the liability protection afforded to a particular cell requires and is dependent upon the observation of certain formalities in the formation and continued maintenance of the parent series LLC. One, the parent series LLC company agreements got or may establish various classes of members or managers associated with each separate series or cell, and it may provide for certain voting rights, powers, and duties to be attached to those classes. Now, the IRS didn't determine tax treatment until 1996 on LLCs, and they established the check-the-box taxation system. And as I've indicated before, a single member can choose to have the LLC disregarded entirely, or it can and have the income reported on Schedule C or Schedule S of the IRS 1040 form, or it can also choose to elect to be treated as a C corporation. And if there are multiple members, they can choose treatment as a partnership, a C corporation, or an S corporation, and you just check the box. Now, until September 14th of 2010, just a mere 9 or 10 months ago, the release of proposed regulations regarding the federal tax classification of a domestic series was not certain how or whether a series of an LLC would be classified under the check-the-box regulations. But now it's clear. each and every separate cell or separate series is going to be subject to independent taxation and classification under the check the box series. So obviously the primary purpose of using this series LLC concept is because you pay one filing fee, one attorney's fee, and then you have virtually an unlimited number of independent cells that you can then use to hold major assets. But that doesn't relieve you of the obligation to separately account for each separate cell and to file file a tax return for that separate cell. And if it's got combined ownership under our rules, you'll have to file a combined return for state franchise tax purposes. But if you think about it, the alternative is to go out and form a new separate LLC every time you want to hold a new asset, a different asset in a separate LLC. Now you got another filing fee, another legal fee, and you're still going to have to separately account for it, and you're still going to have to file a tax return for it, and you're still going to check the box, and you're still going to have to file a franchise tax return. And if they're common ownership, you're still going to have to file the combined return. So this is an administratively simpler, easier, and more flexible system with one entity and one attorney's fee and one filing fee, and then you got much more flexibility to hold each asset. Now you're going to have to identify those assets as in a particular cell, which you're going to identify in the company agreement and in the certificate of formation. Now there's some unresolved issues. I'm getting ready to give a speech in December of 2011 to the Dallas Bar Association Real Property section, and in September I'll be speaking to the Dallas Area Real Estate Lawyers Discussion Group, and I've decided to title that paper Series LLCs in Texas, A Coming Trend, or Too Many Unanswered Questions, and then the subtitle is The Good, the Bad, and the Ugly. And if I can do it, I'll sound the music from the music, because it has some good, it has some potentially bad, and the ugly is perhaps the unknown. So here are the unresolved issues. What about state sales taxes and franchise taxes? Well, I think the franchise tax issues are going to be fairly easy. They're going to treat each separate cell or series as separate taxpayers for franchise tax purposes. I've already said that I thought that was the appropriate treatment. Securities laws treatment. Well, they're going to have common ownership, so if there are integration issues that are going to require you to disclose the relationship between these entities in the securities laws context, that would be expected. But at the same time, they are separate legal entities. They just have some potential overlapping common ownership interest. So how much are you going to have to disclose? That isn't clear. So it's an unresolved issue. Whether an insolvent series, a separate cell, can enter into bankruptcy independent of the other series LLCs, of the parent series LLC, or independent of the other cells or separate series. Well, to me, since they're going to be treated for liability purposes, income tax purposes, and franchise tax purposes as separate entities, that means they can enter bankruptcy independent of the other separate series or cells, and independent of the parent series LLC. Just like a parent corporation doesn't have to file bankruptcy in order for the subsidiary corporation that may be even wholly owned by the parent corporation. So I think that bankruptcy treatment, even though it's not known, is pretty predictable.
So when you say that, there hasn't been any case law? Is that basically what we're waiting for, is a judge to make a ruling, or
exactly.
A few judges, a few cases?
Now, if you think of, yes, exactly right. We're waiting to see what the law might be. Now, we've got 16 years of experience in Delaware, but there's limited authority coming out of Delaware, and our statute isn't identical, though it's very close, so we could use that as some authority. But to me, it's pretty easy to imagine that a bankruptcy court would decide that you can't put the series LLC, the parent series LLC, into bankruptcy and automatically get the protection of bankruptcy for all the independent subsidiaries, the independent cells or separate series by that. And so that means if you're trying to put all of them into Chapter 11, you may have to pay a filing fee of $1,139 for each and every independent entity that you want to put in.
Yeah.
Or if you're going to file a Chapter 7, you may have to file a $299 filing fee and have a separate, you get the idea. I think the law is going to ultimately treat these entities as separate entities that are treated that way for tax purposes, for liability purposes, for franchise tax purposes. And now the hard part may be, what if you get a contractor's license for your parent series LLC? Does that mean the subsidiaries can use that license? What if you've got a parent series LLC that's a licensed real estate broker? It wants to hold separate assets in the children, the offspring series LLC. You get the idea. There are unanswered questions. I think in general the law is going to come down on the side of, wait a minute, if it's got separate liabilities and separate assets and has to pay taxes and file returns separately, then it's going to be treated as a separate entity. And what we're getting primarily is the efficiency of filing one entity and not having to keep going back to the well every time we want to get another entity formed. Now, whether the internal liability shield of a series, of a particular separate series or cell, is going to be recognized by another state that hasn't adopted series legislation, that clearly is a problem. You know, if you're going to try to hold an asset that's in another state and that state hadn't yet come to recognize series legislation, well, it's easy for me to imagine that you're going to have a problem with the laws of that state. So what lessons do we learn there? Well, the easy lesson to learn is maybe the only thing that your Texas series LLC should own in the way of assets, or its offspring or subsidiary cells and separate series, should be Texas real estate. We know what the legislation says, and I'm going to get to that in a minute. But maybe you don't want to operate a business that operates across state lines where that other state where it's operating doesn't recognize Texas series LLC legislation.
Okay.
Whether a judgment creditor of a member is going to be confined to a court order to charge the LLC interest to the member. I still think that's going to be the law, but we don't have any case law on it. It's still in its infancy. Generally, lawyers who are helping people with their business decisions like certainty. Now, the trial lawyers, they love uncertainty. That's the grist of their mill, is the uncertainty that lies in statutes and agreements and et cetera. So that's perhaps the best argument yet for why you don't necessarily want to use one. Well, for some people I know that have many, many, many properties, they don't mind separately accounting for each property. They think that's good business practice anyway.
Right.
They don't mind filing a separate or combined tax return because they're going to have to do that anyway if they have overlapping ownership. They don't mind filing separate income tax returns because it's not that hard to do if you're already separately accounting for it,
Right.
and particularly if it's a partnership return or something of that nature. But for the time being, and frankly, I haven't revisited the American Bar Association's recommendation now that the IRS has at least given us some tentative rulings on how it's going to be taxed for federal income tax purposes. But it's easy to imagine the American Bar Association is not going to jump right in. And first of all, they're a national organization. We don't have it. We don't have a uniform act that's been passed by all 50 states yet, like we do with the Uniform Limited Liability Company Act. It's going to probably be best used by non-operating passive investments not involving multiple jurisdictions. And when I say non-operating passive investments, I don't mean that you can't have a piece of real estate that generates income, but certainly one that doesn't involve multiple jurisdictions in other states. Here's the basic law. So the reason I'm putting this in this presentation, George, is because I think it's important for people to see the actual language of the statute and see that it says what I'm saying that it says. The company agreement can establish or provide for the establishment of one or more series of members, managers, etc., that has separate rights and powers, separate business purposes. The series can established, as stated above, can carry on its own business, purpose, or activity that's not prohibited.